In these cases where firm after firm after firm after firm comes in, works, and withdraws, at what point does the court say this is the final line? And that the court would be looking at billings very closely to determine. This is the matter of the guardianship of Garrett Dosch, 99G020357. I'm Judge Linda Marquis, all by myself in the courtroom. On the telephone, Mr. Berchtold. Mr. Berchtold, your appearance for the record.
Good morning, Your Honor. Jim Berchtold, Legal Aid Center of Southern Nevada, bar number 5874, appearing on behalf of Garrett Dosch, the protected person.
Ms. Brickfield, your appearance for the record.
Good morning, Your Honor. Elizabeth Brickfield, bar number 6236, guardian ad litem for Garrett Dosch.
Also on the telephone, Mr. Willick. Mr. Willick, your appearance for the record.
Good morning, Your Honor. Marshal Willick, 2515 for Raina Dosch.
You have with you Ms. Cole. Ms. Cole, your appearance for the record.
Good morning, William Cole, bar number 119.
And also on the telephone is your client, Ms. Dosch. Ms. Dosch, can you hear me all right?
Yes, I can.
All right. Also on the telephone, Ms. Goldsmith. Ms. Goldsmith, your appearance for the record.
Your Honor, I'm actually on Blue Jeans. Dara Goldsmith, bar number 4270 for Travis and Melodie Dosch.
Okay. We also have Mr. Waite. Mr. Waite, your appearance for the record.
John Waite, attorney bar number 15110.
Ms. Barney, your appearance for the record.
Good morning, Your Honor. Tiffany Barney, bar number 9754, creditor of Guardianship Estate and judgment creditor of Raylene Dosch, and I represent Anthony L. Barney Limited.
Mr. Biedermann, your appearance for the record.
Fredrick Biedermann, bar number 11918. I'm representing the law firm George Cox Larson, creditor for the estate of Garrett Dosch, former counsel for Edith Raylene Dosch.
Mr. Hughes, your appearance for the record.
Lynn Hughes, bar number 6349, on behalf of the Roberts Office.
Also on present via audio visual, there was a media request by our Nevada judges. They are also recording.
Best interest is not, can you give her a pony?
Ask the question, make sure we're being accurate with what the document states.
To find out what the facts were. I agree, the record's a mess.
I make a finding that paternity has been established.
He was a potential future to his children.
We're here for the court's order to show cause. Okay, so that takes care of one motion.
Council, did I get all of everybody's appearance, or did I miss someone? It sounds like I didn't miss anyone. Thank you all for being here. We have a mix today of Blue Jeans audiovisual appearances and telephone appearances in the courtroom. Our telephone has been acting up today. So if I lose somebody, please call my department, and we'll try our very best to get you back on the line as soon as we can. If somebody misses something, please feel free to interrupt so that I can ask the person to respond. But I'm gonna kind of guide us through this today. We have a lot on calendar. We're gonna take our time so that everybody has an opportunity to be heard today, unless anybody wants to submit anything on the papers. So today seems to be a day of fees. Let's take the first request, though, by Ms. Brickfield. Ms. Brickfield, your request for fees for the expert. Go ahead.
So, Your Honor, Dr. Brown and Dr. Kinsara were appointed by consent of by stipulation of the parties, and it turns out that the amount that Dr. Brown was paid was less than the amount that he's owed. So I'm simply asking, Your Honor, that the funds be released to pay him the balance of what he's owed, which I think is $39,0625 without interest. I will prepare the order, and I will take the responsibility to go to the bank and get the bank check.
Mr. Berchtold, any objections?
No, Your Honor, no objection.
Ms. Goldsmith, any objections?
No objection.
Mr. Willick, any objections?
None, Your Honor.
All right, I believe that the other parties will not have any objections, but do any of the other attorneys on the phone have any objections?
No, Your Honor.
No.
Ms. Brickfield, your request is granted, there being no objections.
Thank you, Your Honor.
As you stated, please get an order to my electronic drop box. I'll sign off on the order, and then you can proceed as you articulated. All right, let's go to fees. Let's start backwards, going forwards with Mr. Hughes' request for fees. Mr. Hughes, anything to add?
No, Your Honor, I'll submit it on my pleadings that have been filed, including all objections, etc.
All right. Okay, Mr. Berchtold, your objection specific to Mr. Hughes.
I won't go through a restatement of my objection, Your Honor. I'm sure the court has read it. My primary objection is that no notice of intent to seek fees was filed under NRS 159.344. Other than that, I'd be happy to entertain any questions.
Counsel, how do we measure a benefit to the protected person, especially in a case like this? Mr. Berchtold?
Well, I think some advancement of the case would be a benefit to the protected person, Your Honor. Some tangible, something that you can point to say that the case has been moved forward, that Garrett has been, that his position has been advanced in some way, that he's been benefited in some way. To date, between the three petitions, we're talking about $120,000 in attorney's fees, and the case looks markedly like it did in 2017. So I think there has to be something that can be pointed to say, here's where a difference was made that benefited Garrett. And I don't see anything in any of these petitions.
Ms. Brickfield, as to Mr. Hughes' petition.
Your Honor, I don't have anything to add to what I submitted to you and to what Mr. Berchtold added. I don't see that there's been any benefit. Through the guardianship estate, I don't think we're any further than where we began when Mr. Hughes began his representation.
Ms. Goldsmith?
I would echo the comments of Ms. Brickfield and Mr. Berchtold, and I would also add that if you drill into the time, a lot of, even if you get as far, if you decide you're going to look at the time, a lot of the time that was built is for secretarial or administrative work. But I don't even think you get that far.
Thank you, Ms. Goldsmith. Mr. Willick,
Yes, Your Honor.
do you have any objections?
I'd asked Ms. Cole to participate. I had to leave the call with our client before that topic was raised. I apologize, but we just got into this case and I haven't completed our Rule 11 investigation.
All right, Ms. Cole.
I can only represent what I discussed with the client, what I'm operating saying, that is she was going to leave it up to the court's discretion on how to handle.
Okay.
You know, if you look at the pool of paid attorneys, I guess I'm not sure if paying money at the end, they end up leaving the Dosch's estate. So I'm not sure whether it will be paid out of the same amount of funds. For, you know, we just came on this case. We were barely getting into review of the files and understanding. I can't speak to the length of the review stuff because I just haven't been able to get that far in my review. But our client didn't have a sincere.
All right, Mr. Hughes. Okay, Mr. Hughes, anything you'd like to say?
Your Honor, no. I understand the position of all the parties, and I even agree with much of it. I think the court understands the situation, and that despite whatever going on, I believe the firm would be treated fairly. So, no, Your Honor, I have nothing more to add.
Thank you. I am going to deny Mr. Hughes' request for fees for two reasons: failure to file notice of intent, and also no benefit to the protected person. Now, I will say this. This decision does not speak to Mr. Hughes' intentions or Mr. Hughes' good faith in trying to work in this case. Mr. Hughes has requested to withdraw. That request was approved and granted. I think that the statute, though, however, does not take into consideration an attorney's goodwill, intentions, best efforts. What it does take into account is any benefit to the protected person. And here we've not seen that benefit. So his request is denied. Moving back to Mr. Cox's office, Mr. Biedermann, your request for fees. Anything you'd like to say at the outset?
Nothing in addition to what I presented in my petition and in my reply. I believe that this firm did everything we could have done to advance the best interests of Garrett. Unfortunately, as you know, the case is hotly contentious, and that there are parties in this case that will object to anything that the Guardian does, no matter what. And I believe we did everything we could to advance Garrett's best interests and while representing the Guardian. So nothing in addition. I mean, really nothing in addition to what I included in both my petition and my reply. And I will add, Your Honor, we did file our notice of intent to seek fees from the estate back on February 14, 2018, approximately a month after we became counsel for Ms. Dosch.
Thank you. Mr. Berchtold, as to Gerard Cox Larson request for fees.
So, Your Honor, at the risk of repeating myself,
I'm going to let you repeat yourself, though.
The work that was performed simply didn't have any benefit to Garrett. Again, the case is pretty much the same as when Gerard Cox took up the case. None of the work was successful. All of the things that were worked on during their tenure still remain outstanding. And the work was unnecessarily expanded, not necessarily through the fault of Gerard Cox, but as Mr. Biedermann said, this is a hotly contested case. And unnecessary work was required. The request for $45,000 in fees for essentially a year's worth of work is not just, it's not reasonable, and it wasn't necessary.
Ms. Brickfield.
Your Honor, I don't have anything to add to what Mr. Berchtold said and what I said in my written joinder, except that I did find a benefit to that one meeting when Mr. Biedermann brought the Dosches to my office and I was able to meet with Garrett for a period of time, as well as with Ms. Dosch. I did find that one $750 charge was beneficial.
Mr. Berchtold, in that vein, did you find any part, or would you concede that perhaps that part of the representation was beneficial? Do you see any other part of the representation being beneficial?
I do, Your Honor. Actually, I have no objection to the benefit that the guardian ad litem pointed out, the $750 charge. And I also think initially when Gerard Cox firm got in the case, they completed the appointments for the guardian. They did the letters of guardianship and a couple of other documents that equaled roughly around $3,000 worth of work. I have no objection to that.
Ms. Brickfield, would you agree with Mr. Berchtold's statements?
I would, Your Honor.
All right. Ms. Goldsmith?
Your Honor, I would agree with what's set forth in our joinder. Additionally, I would agree that the meeting that Ms. Brickfield had was beneficial. And I would agree that the work performed in completing the letters and items of that nature for the $3,000 was beneficial as well. There's nothing additional that I would add as beneficial at this time.
Ms. Cole? Okay. Ms. Cole, let me just make sure and confirm your position on this request for fees is similar to your position on the request made by Mr. Hughes?
Yes.
All right. Mr. Biedermann, anything else you would like to add?
Well, yeah, I have a few things I'd like to say.
Sure.
For my reply, Mr. Berchtold claimed that our firm admitted that our firm did not unnecessarily expand the issues of the case. He just said that the issues in this case were unnecessarily expanded, but he admitted that it wasn't our fault. Under the statute, the court is to look to whether the person seeking fees paid or the attorney seeking fee pays unnecessarily expanded the work in this case, so the issues in this case. And Mr. Berchtold admitted that was not done by our firm. So I want to make that point clear. Second of all, under 159.344B, the statute specifically says that the court is to look to not only whether an actual benefit was conferred upon a protected person, or whether it also allows the court to look to whether the attorney attempted to advance the best interest of a protected person. And throughout our whole representation, that is what we attempted to do. We filed an inventory. The inventory still remains contested long after we left this case. And we filed a budget. The new budget was refiled exactly the way we presented it. It still is contested by Garrett's brother. And I believe that the legislature intended to allow for payment of attorney's fees even in cases like this, because all we did was attempt to advance Garrett's best interest. Now, whether or not that's out of our control because it's not approved, that shouldn't be put on us. We shouldn't be penalized for that, because other parties continue to object, will not make any concessions, would be to come to a very expensive evidentiary hearing, which would not confer a benefit to Garrett's estate. I really want to point out that in my reply, I point out how in the objections filed against our petition, the law was misrepresented. It's not only if an actual benefit is conferred, there's a variety of factors the court is to look to, including whether or not the attorneys attempted to advance the best interests of the protected person. And that's what our firm did.
Counsel, can I ask you this? As everyone has stated previously, this is a contested matter that has not had resolution in the last few years, has not had advancement. How does the court measure benefit? How does the court measure the intentions of counsel without direction from the Supreme Court and the statutory scheme? The intention, and let me say this, that the intention of counsel could be measured or evaluated, but that intrudes into two things: work product, the intention of another lawyer, which is, just plain difficult to get to, and attorney-client privilege. In these cases where firm after firm after firm after firm comes in, works, and withdraws, at what point does the court say this is the final line, that the next firm that comes in, they should know or should have known that this is a difficult matter, and that the court would be looking at billings very closely to determine their intentions or whether there's real advancement or benefit to the client? And at what point in time, I know this is a totally compound question, at what point in time is an evidentiary hearing the only way to reach a conclusion in this case that would result in advancement?
Well, Your Honor, I understand that that's a very complex question and it requires a very complex answer.
I'm going to give you the time, counsel.
Okay, well, I think I included several facts in my reply to give context to what's going on in this case. And I think it's important for the court to understand that when Ms. Dosch petitioned to be guardian of the estate, that she faced a contest from her son Travis. And the guardians who represented Ms. Dosch at the time served Travis with discovery requests, and Travis refused to respond to any of them. He only responded with objections. And then when Ms. Dosch's counsel sought to a motion to compel and for discovery sanctions against Travis, he inexplicably withdrew his petition. So I know that the court is looking to the intent of the attorneys representing a guardian, but I also think it's important to look at the intent of the person who's constantly objecting to all the filings in this court, the inventory, the budget, and the accounting. And you know what? Back in the day, before all the reforms were made, I think any attorney wouldn't hesitate to have taken this matter to an evidentiary hearing. I mean, I personally don't believe an evidentiary hearing would benefit Garrett in any way. I think the issues in this case should be and could be resolved, but I personally don't believe Travis is acting in good faith. I believe he wants to punish his mother for whatever reason I do not know. But I think it's important the court to not just look at the guardian and her attorneys and what their intent is. I think the court should look at what the intent of the person who is objecting to everything. And I think the court should look at what happened at the beginning of this case when Travis refused to provide information about his suitability to be a guardian and his inexplicable withdrawal of his petition. I believe that his objections are done in bad faith, and that withdrawal of his petition provides that context. So, yes, I don't believe that this should be going on. I don't believe that evidentiary hearings should have to continue in this case. But unfortunately, if petitions for fees are denied under these circumstances, we're going to face a situation in our guardianship system where only the person who has money to constantly object to whatever the guardian does, and the guardian does not have the funds to protect herself, we're only going to be in a situation where only the people with money will be able to protect the interests of their loved ones.
Counsel.
I understand it's a complex situation. I don't know exactly when that should end. But I think the court should look to what exactly is going on and look at the intent of all the parties, not just the guardian. Because I personally believe that Ms. Dosch is looking out for the best interest of her son. She has for the entire time he was born. And no one should be able to dispute that. She's not living on the hog. She lives in a setting that most people would consider less than modest. She lives in a trailer home, and but no one's looking at what the intent of Travis is. You know, he's asking for unsupervised visitation. He was absent for 15 years, and now he's asking for unsupervised visitation of his brother. And what's his reason for that? What's his motive? People should question that. And so we have a situation where one party has unlimited funds. By the way, Travis received the same judgment that Garrett did. That is funding his estate. So Travis has the funds and the pockets to object to everything as long as he can do with it. But does the guardian have that same situation? No, she does not. And unfortunately, this is all done to Garrett's detriment.
I think that, I don't disagree with all of your statements about the status of the statutory scheme in Nevada and the changes in our statutory scheme put attorneys' fees and the actions of all guardians under a microscope. That is every detail, every $6, every 50 cents is reviewed by me. And I think that sometimes that is a little bit too much, but that's the state of the statutory scheme. It gives the ability of people in the community of no relation to the protected person to make objections, to be present, and leaves everything out to public consumption. But that's the state of our laws, and those are the laws that I have to apply, and I do apply in this case and all the other cases. I understand your concerns, counsel. I think that I am going to, in this case, grant the request in part. I am reviewing the billing statement line by line. Counsel, I would like an order from you with a blank in the attorney's fees portion submitted to my department electronic box. I would like that in a format that I can edit because I will add additional findings and a line-by-line analysis of the billing statements. So if you could get that to me, not in PDF form, but in a form that's editable by me, I would appreciate that. Thank you.
Microsoft Word would be appropriate for you.
Word is appropriate, although you know that I love WordPerfect. The county doesn't let me use WordPerfect. I can only use Word.
Our firm usually uses WordPerfect, but I use Word in this particular case because I'm assuming more people are going to be involved in having to make that. So I'll submit it in Word.
Thank you, counsel. Somebody,
give findings of fact and conclusions of law, but you will add additional things and leave the amount blank.
Yes, please. Thank you, counsel. Ms. Goldstein.
I just would like to point out a couple of factual inaccuracies from Mr. Biedermann's statements, if I may.
Go ahead, Ms. Goldstein.
First, I'd like to point out that my client is not the only party who objects. That there's been objections by the guardian ad litem, Ms. Brickfield, in addition to my client's objections. And Mr. Berchtold has also raised some issues as well. I think it's important also to note that my client did produce significant discovery. My client did respond to inquiries, so the statement that he did not comply, he may not have complied in the manner which Ms. Barney would have liked, but there were a lot of documents and information produced and responses to questions, not merely objections. So I would like to point that out as well. And finally, I think it's important to note the other misstatement is my client does not receive the same settlement or income that his brother does. So those are all factual inaccuracies.
Thank you, Ms. Goldsmith.
And if you need an affidavit from my client and myself to support that, I'm happy to provide the same.
I
would
don't.
like to add,
Go ahead, Ms. Barney.
Just because I was the attorney that was on the case while the discovery was going through, Travis did not produce personal information, and he did not provide, he or Melodie, any financial information, which for a guardian of the state would have been which was needed. And so he did not provide any financial information and would not provide personal information. So he did provide some discovery, but the discovery that was relevant to the guardian of the estate, he did not provide.
Thank you, counsel. Thank you. Moving on to Ms.
Can I add one more thing?
Yes, go ahead, counsel.
Okay, I want to add one more thing, and this has been a concern of mine throughout this case. I know that Ms. Goldsmith brought up the guardian ad litem, that she had made objections. I think I don't know how important this is to bring up, but I think it is important in the context of how contentious this case is. I'll give you, from the moment the guardian ad litem was appointed, she has essentially vilified the guardian from the very beginning. And she, in my opinion, has not looked out for the best interests of Garrett. And one example is a petition for unsupervised visitation that Travis filed back in December of 2018. Now, as I mentioned, Travis was out of Garrett's life for 15 years. He was disappeared. And the guardian ad litem filed a joinder to that petition. Yes, let's have unsupervised visitations with a relative who was out of Garrett's life for 15 years, and I'm not going to question, and we're not going to question that. We don't know what Travis is going to say to Garrett, and Garrett does not have the ability to communicate anything that would take place with Travis under a supervised visitation context. I had an email shortly after that meeting that we had with the guardian ad litem, where she all but accuses the guardian of attempting to murder her son. It was pretty clear what the guardian ad litem was trying to say, and it was pretty outrageous to do so. It was over a comment she made about the family history in the case, that the women in the Dosch family lived long and the men died early. But the guardian ad litem, ever since then, has vilified the guardian every step of the way, never gives her the benefit of the doubt, and goes along with whatever Travis wants without question. And that is something I think the court should be aware of. And if the court goes back, looks at that petition for unsupervised visitation, she will see the guardian ad litem joined the petition for unsupervised visitation without questioning the wisdom of doing that with a relative who was absent for 15 years, and as I might add, what Ms. Barney said, refused to provide any personal information when he contested guardianship.
Counsel, I don't want to get too far afield. It's difficult for us to communicate. The issue that is on calendar today is attorneys' fees and costs. I want to deal with those issues. The objections that have been made to the request for attorneys' fees and costs are statutory objections. They do not reach back into back and forth between counsel in this case for years and years going backwards. I know that this case has a tortured history. I know that it has been difficult for some people to work together in this case. I will say, that I take everybody's voice and hear it in this case. I don't think that Mr. Berchtold or Ms. Brickfield have taken up the banner of any party other than Garrett. And they at times have both objected to what each party has done. They sometimes Mr. Berchtold and Ms. Brickfield disagree. I appreciate and need their perspective, their history, their relationships. In this case, I have reviewed the history of this case and am very familiar with it. And so I think that it's important that we stick today and move forward with the issue of fees. Ms. Barney, as to your petition, please.
As to my petition, excuse me, I think what's been lost is that, we are a creditor and a judgment creditor of Edith Raylene Dosch, or Guardian Dosch, and because of our status as a judgment creditor pursuant to NRS 10.045, and also the accompanying case law that we cited in our reply to the Guardian ad litem jointer, we can pursue the personal property of the creditor, which includes actions such as requesting attorney's fees and costs that are being sought in this matter. And Guardian Dosch certainly has the right to request those funds that were personally expended by her for the purposes of furthering the guardianship. And we did provide a benefit when we were representing her. We complied with the court orders while she served as the guardian of the person and temporary guardian of the state. We did what was in the protected person's best interest. We also avoided a lengthy trial, as Mr. Biedermann pointed out. We performed the discovery to discover why Travis and Melodie wanted to become guardians of only the estate of Garrett Dosch, and basically we were provided with little to no information, their personal information, and absolutely no financial information. I mean, this resulted in motions and other things being filed, but ultimately we were able to avoid a lengthy trial in this matter, and we were ultimately successful in appointing Guardian Dosch as the guardian of the state while we were representing her. And as briefed in the petition and the reply, we have met all the factors listed under NRS 159.344, or some of the factors were inapplicable. But I noticed that in the oppositions, there were no specific objections to the analysis of any of these factors or in any of the jointers to the opposition. And yes, while it is true that the prior judge did not award fees to Guardian Dosch because there was no final inventory or budget made at that time, NRS 159.344 has now become the new law, and inventory has been provided. It shows the baseline amounts that are in the guardianship estate. I know that there's been some objection, but the objection is to include more assets in the guardianship estate would actually increase the favorability of our petition being granted, honestly. And the court at this time is able to do an analysis under subsection 5J of NRS 159.344 because, one, it knows the value of the estate. It's approximately, I believe, $360,000, and our current request for fees is only 5% of that. The court knows the nature, extent, and liquidity of the assets. They're all in a bank account at present, and they're completely liquid. The court knows the disposable income of the estate. Each month, it's $5,150. The monthly budget takes $4,000. There's a surplus of $1,000, over $1,000, and there are no major foreseeable expenses, or except what I've heard here that Dr. Brown and Dr. Kinsora still need to be paid. But other than that, the court has the ability to make an award of attorney's fees and costs from the guardianship estate based on the information that it has at present. And all of the requirements have been met concerning our petition, and we just request that the court pay us the amount of the $20,500.03 that we've requested.
Mr. Berchtold.
So, Your Honor, this is the petition that I find the strangest. The $20,500 has already been paid to the Barney firm directly from the Guardian. So the Barney firm's response to that is, well, the guardian has the right to seek reimbursement. And that is correct. The guardian has the right to seek reimbursement. I don't know of anything in 159 that allows a former firm to pursue this claim on behalf of a former client without that client's consent or involvement. If the guardian wanted to assert this claim, she certainly could, but that claim would be met with substantial objection by all parties, as the court, I'm sure, is aware. Even if she was successful and that money was awarded to her, that reimbursement was awarded to the guardian, at that point, the Barneys could absolutely seek to enforce their judgment. The guardian, in response, could claim an exemption to try to avoid that. So there are about 5 legal processes that the Barneys are trying to skip over in order to get that money. So it doesn't make sense, and I think the petition should be denied.
Ms. Brickfield.
I don't have anything further to add, Your Honor.
Ms. Goldsmith.
Nothing to add, Your Honor.
Ms. Cole.
Nothing further to say the Barney firm, although there was one comment I like in general, some of the objections that were made in writing. And it's been a little difficult to hear everyone clearly, and I don't believe it's been discussed, but there was a mention in the objections that the collections have not been accomplished from the judgment outstanding for Mr. Goldsmith. And I did have a conversation with Garrett's attorney, Mr. Berchtold, and I don't have any independent knowledge of this, so I'm going to go off with what someone who knows a lot more of Mr. Berchtold told me, and that is Mr. Goldsmith is uncollectible in his judgment proof. He has no assets. So I don't know that any attorney for the guardians attempt to collect that judgment would be worth their time, and I don't think that's a valid reason to object to their request to you. Other than that, I have nothing to add.
All right. Ms. Cole, let me ask you this question. Mr. Berchtold raised a concern that $20,500 had already been paid by the guardian in this case. And now, and the statutes certainly allow for a guardian to seek reimbursement for costs or fees paid or advanced on behalf of the protected person. Here, though, we have a law firm requesting the fees that is no longer representing the guardian. Do you have any position on that issue?
Well, I mean, as long as they were engaged in services in the scope of the representation of the guardianship, are you asking me whether the time has passed?
No, I'm asking you about the payment of those fees already by your client, the guardian.
I think that the statute, whether it allows for reimbursement.
Well, I told you that I think that the statute does allow the guardian to seek reimbursement. Here, they are seeking fees which have in part already been paid by your client.
Okay. If they're asking for fees that have already been paid and they're double dipping, clearly that would not be appropriate. And I want to make sure I understand your question. I apologize.
That's okay. That's okay. And I know we have a bad connection, but I just wanted to confirm whether or not you had any position about whether your client is involved with the Barney's request for fees that perhaps have already been paid.
I can't speak to her opinion on that, Your Honor, because I have not had a chance to consult with her about that.
Okay. Thank you. Ms. Barney, do you want to say anything in closing?
Yes. Basically, as a judgment creditor, we have rights to be able to seek the property. And herein, this action is under NRS 10.045, and this personal property is subject to execution in satisfaction of a judgment. We have a judgment against her in this matter. He has not opposed that, and certainly I filed this petition when Mr. Hughes was still her counsel, And so I understand that it's a Willick law group that just came on, so they didn't have a position. But I mean, I can assume that Ms. Dosch would want us to be able to seek these fees from the guardianship estate instead of from her directly. And we have the ability to do so pursuant to statute and case law because of our status as a judgment creditor. And so we believe we are very well within our rights to be able to seek these amounts on behalf of Guardian Dosch. And obviously I believe she didn't object because she would rather have the guardianship estate pay us than have her pay us personally for those funds. And because the statute allows for a guardian to seek reimbursement for personal payments that are made in furthering the guardianship, which we did, we can seek these fees.
Great. I'm going to deny Ms. Barney's request for fees today. I would ask Mr. Berchtold to prepare the order denying the request from fees. I think that we've skipped, there are several reasons as outlined by Mr. Berchtold and Ms. Brickfield. I'm concerned that as a judgment creditor and without, and certainly the guardian can seek reimbursement. It's up to the court, subject to hearing objections, to approve that reimbursement. Those things haven't been done. I understand that some fees have been already paid, and that they can certainly execute on the judgment that they have, but they can't execute this judgment on the estate without a request first by the guardian. That hasn't been made. Thank you. I think that takes care of all the issues on calendar today. We have a date scheduled for June 17th, 2020 at 1:30. Council, I expect that on June 17th, we will still be meeting with each other via audio-visual equipment. I understand that Mr. Willick and Ms. Cole are new to this matter. I am going to ask that Mr. Willick and Ms. Cole have an opportunity to speak with Mr. Berchtold, Ms. Brickfield in this case so that they can be updated on everything that's been going on, and so that at that June date we're up and running and ready to go.
Yes, Your Honor. Two things in that regard. This is Marshal Willick. First, Ms. Cole apparently was dropped by the AV system, so she's no longer online. Second, I should inform the court that we have already begun that process and have completed about 2/3 of the phone calls. We are interested in, the court knows that I'm rather neurotic about completing a Rule 11 investigation before committing to a position. And we're not done. The file is, I don't have to tell you what the file looks like. But it is possible, and I hope I don't sound Pollyanna-ish and I'm sorry if it sounds like I'm naive, but I am still hoping that there is a way of finding a resolution which is going to be acceptable, and if presented to the court, would simply allow the combat to end, because it's in everybody, especially Garrett's, best interest if that way forward can be found. And I think it is possible. From my review of the file, it's a matter of understanding your way out of it. And we have some ideas, and I've received some good indications of cooperation in various regards. I have hope. I don't want to be pie in the sky, but I have some hope that this case may be resolvable.
Thank you, Mr. Willick. I note that Ms. Cole did allude to conversations over their telephone with Mr. Berchtold, so I was hopeful that you'd spoken to both Ms. Brickfield and Mr. Berchtold. I know that there is a resolution that can happen in this case that will benefit everyone, but most importantly, benefit Garrett. I am happy, as I've explained to counsel previously, to do whatever I can to help you resolve this case. If it becomes apparent at any time that you would like my assistance, or you would like the assistance of a senior judge or a mediator or absolutely anything else under the sun that I can get for you to help you resolve this case, I will do for you. So counsel, you may jointly contact Chambers if you have any such requests.
Thank you, Your Honor.
Thank you. Good luck.
Yep.